Okay. If I could ask everyone to quiet down, please. Oh, wow. Well, that would scare me too. Oh, you don't have to stand up again. We're here. Yeah, all right. But we really appreciate it. I think they were just trying to get everybody to quiet down. All right, we're here for oral argument on Montenegro versus Fontes. It's our number CV24-0166. All counsel here are very experienced. You know you have 20 minutes each. Keep whatever time you wish for rebuttal. Mr. Langhofer, you look like you're ready to go, right? You're going to be the one, so go ahead. I don't know that's working.
Good morning, Your Honors, and Madam Chief Justice, may it please the Court. Corey Langhofer, together with my colleague Tom Basile, for the Speaker of the House. I'm going to be addressing standing this morning, and at the time remaining, my colleague Brett Johnson will speak to you about severability. And the Court of Appeals just forgot about the second thing. The first thing is the most obvious. It takes text, it refines that. When it approves it with the governor, it becomes law. It's the approval function. The other thing the legislature does, though, is the rejection function. And quantitatively, this is actually more important. More proposals are rejected than are approved. The difference between the approval and rejection functions, though, is that rejection can be done unilaterally by either chamber. So if one chamber doesn't call a bill for a vote or votes it down, it does not become law. Prop 211 injures the legislature because it reduces, it significantly impairs the rejection function.
Mr. Langhofer, before you get too far down that road, I confess that I'm not sure that I understand all the procedural posture of this case, and I just want to make sure that I'm on at least the right page. Because the two issues that we have here are, one is standing to the Court of Appeals with a correct in saying that you don't have standing, and the second one is that is subsection D severable. It seems like the second begs the question that usually doesn't come up until we make a determination. Are you likely to succeed on the argument that the entire act is facially unconstitutional? So the way I see it, we're kind of looking at, you have to address that issue before we can get to the second, rather than just abstractly answering, yes, you have standing, yes or no, or yes or no, subsection D can be severed, because where would we go with that? We don't usually just give advice, we have a consequence. So can you help us as to what precisely are you asking us to do?
So the Court of Appeals, of course, found that there was standing for subsection D, but found not for subsection A. And what I think the remedy we're looking for is a finding that there's standing, and then a remand to the lower courts to address the merits. And
remand to the Superior Court.
I believe that's what that would be appropriate. The Court of Appeals also declined to address the merits. So if you wanted to go back to the Court of Appeals, I don't think it would be improper, certainly within your discretion.
And are you addressing standing only as to Section A? Because there are some points where the briefs say the whole act is being challenged and all of the rules, even though only 3 are ever mentioned.
So Mr. Johnson will be arguing that the D is not severable, and therefore the entire proposition should be invalidated. On the sort of...
Let me press the point just a second there, Mr. Langhofer, though. I think Justice Birch is asking, if this is a facial challenge, why would we consider standing on an individual subsection basis? Why wouldn't we just look at standing as to whether or not the legislature can bring a lawsuit challenging the constitutionality of the initiative as a whole? Why do we have to get into a section-by-section analysis?
I would certainly take a conclusion that because we have standing as to D, we have
that gets us to the conclusion. But help me with the reasoning, though. Why wouldn't we look at the entirety of the act and whether or not the legislature can challenge it?
I think it's that the answer to that is quite simple doctrinally. And then it's also simple, and although the doctrine doesn't appear in your case law, it appears in your practice, and I'll explain that. Doctrinally, there's a concept that appears in about 24 Federal Court of Appeals cases that originated in the DC circuit about 20 years ago. It's New Jersey versus EPA. And they had the similar problem here. You've got a constitutional claim. The question is, do you have standing to get there? And it says expressly, you assume the merits are correct. You assume that the plaintiffs win If they're right, would that give an injury that would confer standing? And again, about 24 federal courts of appeals have said that expressly. This court has done it impliedly. In a case that Justice Bullock is very familiar with, the Medicaid expansion cases. There was Biggs versus Cooper, then subsequently Biggs versus Betlack. In Biggs versus Cooper, you looked at standing, and you said, we're going to assume that the Medicaid expansion requires a supermajority. And you found that they did, in fact, have standing to bring that argument. 3 years later, in Biggs versus Betlack, you said, now that we're at the merits, we conclude it does not require a supermajority. So you assumed the merits and then later rejected the merits, right? But you assume we're correct on the substantive claims. If there's an injury, we have standing, and then we get to the substantive claims.
So I understand your point, and I know that's what some cases have said, but I have this concern. Assume the legislature gets the permission to sue from the rest of the body, and then in every case, they just allege separation of powers. So does that mean they have standing and can bring any case anytime?
I think that there's some language in the petition that is perhaps overzealous on that. And so I want to state that a little bit more finely. I think that the legislature can bring a separation of powers claim or a challenge to delegation when one of two things happens. First of all, there's a challenge that is facially overbroad. That's what we have here. And the second would be that there's a proper delegation, but the exercise of it is excessive, so ultra vires. So we've got some pending cases on the EPM. I think you've decided some cases on the EPM that say if the secretary has delegated authority here, but they work in excess of that, it's not binding on the state. So I don't think the legislature could bring a separation of powers challenge if the execution or implementation was incorrect, only if someone's exercising a legislative power incorrectly.
So at least facial validity of the claim is required.
The facial, if Brewer versus Burns addresses this, it says if it's plausibly alleged, that's enough.
I want to ask a follow-up question on that. If the legislature in any given session decided to enact what the initiative enacted, would that be constitutional?
It would not. The fact that this Prop 211, the law came into existence through the people rather than the legislature, is sort of an interesting quirk, but it's not significant constitutionally. Just like if the legislature had adopted this, last session versus 100 sessions ago, if the text of the statute is inconsistent with the text of the Constitution must prevail.
Well, taking that question in a different direction, suppose the commission exercises its rulemaking authority under Section D and does so expansively under Section A8 to regulate campaign finance beyond the initiative because it's an act in support of the initiative. And the legislature takes an action contrary to that regulation. Would this measure preclude the legislature from doing that?
That is, I think, the question that we're...
And especially looking at 16978, which seems to have some bearing on this.
That is the mess we don't need to reach, of course, if we conclude that without any guardrails, without a discernible, intelligible principle, the delegation of authority to the commission doesn't stand. But obviously, if we don't prevail here, I'm sure there'll be subsequent litigation about rulemaking authority that appears to be in excess of what is a sort of fair reading of the text of Prop 211. I hope that addresses your question, Your Honor.
I think it's getting there.
Perhaps I didn't understand it. Would you mind restating that so I absorb it?
Section D gives the commission broad rulemaking authority. Section A8 says that it can perform any other act that may assist in implementing this chapter. And Section 978 seems to suggest if there's a conflict between this chapter and state law, the chapter governs. So suppose the commission, in exercising its rulemaking authority, decides it's appropriate to go beyond regulating the dark money aspects and to regulate campaign finance generally. And the legislature has a contravening act. Would this provision prevent that from happening?
I see now. Yes, of course, the order of operations is Constitution, statute, regulation. You cannot, through Prop 211, invert the second of those two and say a regulation will trump state statute. It has to be approved by, under the text of the Constitution, a bill has to be approved by the governor, the House, and the Senate. You cannot subvert those to something that a commission that's not elected, is not subject to recall, has minimal responsibility, even the governor, passes by their own sort of fiat. I do want to make one more point before turning the podium over to my colleague, and that is that the ability to reject bad text, keep bad text from becoming bad law, has always been exercised unilaterally by each chamber. It could do it alone. The important thing about 211 is it can't do that anymore. What the Court of Appeals forgets is if the Clean Elections Commission passes a bad law, it can no longer be rejected, or neither chamber can keep that from happening unilaterally. They have to do it unanimously now with the other chamber and the governor. That is an impairment of the legislative function.
And that's purely by operation of subsection D, correct?
That is, I think it's,
There's the preclusion for the legislature to make the corrective action rejection.
correct, subsection D does that. But I think that if it applies to A1 and A8 as well. So imagine this scenario where you have a text that's written down, we'll call it Regulation X. And it has a majority approval at the commission. It has majority approval in one legislative chamber and by the governor, but one legislative chamber it does not. If Prop 211 never passed, this would not become law because one of the chambers would reject it. It can do it unilaterally. Because we have 974A1 and A8 though, the commission can pass it and the legislative chamber that opposes it can't stop it. Its ability to stop bad laws unilaterally is gone because of 974A. Thank you.
Before you sit down, Mr. Linghoffer, I know, and before you stand, you can start slowly walking over, I guess. You said A1 and A8, and that is, have you abandoned the challenges for A2 through 7 as far as part of your facial challenge?
I don't know that I'm authorized to say that we abandoned it. I certainly think our arguments are strongest as to A1 and A8. When you look at 2 through 7, those are this sort of Frankenstein blend of judicial and executive authority all in one place. So I think it's fair to say that all of those together make the separation of powers concern more acute than it would be than if it were just executive and legislative power. But because it has executive, legislative, and judicial power all in one branch, the violation is more severe.
Thank you.
Chief Justice, may it please the court, Brett Johnson. With me today is Tracy Olson on behalf of the President of the Arizona State Senate, Warren Peterson. I would like to try to retain 3 minutes. Proposition 211, including the disclosure provisions, represent rooms of the House where the Commission lives and functions. And 16974A provides the Commission a license to add rooms at their leisure. But subsection D, on the other hand, was the roof of the House, intended to provide the Commission protection and shelter from the interference by elected political leaders. The Court of Appeals held that subsection D was unconstitutional. So the question remaining is whether voters would have bought the House Proposition 211 sold to them without a roof.
Well, speaking of that roof, it seemed to be a retractable roof because apparently it's only knocked down for the legislature and not the executive branch. So sometimes it's there, sometimes it's not. How did the Court of Appeals take your arguments and turn this into an as-applied challenge by saying that the subsection D is severable, but only as to the legislature, not the executive branch?
Your Honor, you bring up a very good point, and that was one of our arguments in our supplemental brief and our petition itself is that when they brought out the blue pencil, they really didn't bring out the blue pencil. They said, as applied, going forward, we're going to interpret it. The right approach, and it was clear error by the Court of Appeals, is that if they were going to sever, they needed to take out the blue pencil and strike it. And if they were going to do so, that is the disconnect that the Court of Appeals had here. If you look at the first section when they're talking about subsection D as being unconstitutional and what the defendants were actually proposing on the plain language of the statute was to create a super agency. And in doing so, subsection D was essential to that super agency framework. Go ahead, Your Honor.
Oh, how do we know that though? When you get to, and I know you were going to get to this because I read your brief.
Thank you.
That what the voting public, the reasons why they voted for this, and you were saying, well, they wouldn't have voted for this, but for the fact that they wanted this super agency, as you phrased it, that is represented by subsection D. But how are we to assess that? And is that something that should be done in an appeal of a denial of a preliminary injunction versus sitting this back and letting the trial court figure that out?
Well, Your Honor, it is a facial challenge, so I think this court has the ability to take the pleadings and make legal conclusions. I don't think that there's a factual dispute that needs to go back, and the trial court ruled one way, the Court of Appeals ruled another. I think the first thing, going actually to your previous case, you first look at the plain language of the law. You read it together, and it's clear it's a super agency. Between 974A, 974D, 978B, you're looking at a super agency here that is only able to do it. But let's go even further than the plain language. You look at what was told to the voters. It was going to be the commission that was going to draft the rules and enforcement. It was going to be in every single, the preamble, in the ballot itself, the legislative council, on and on. The things that you're allowed to look at because of what FAN said is, look at what was told to the voters. If you remember FAN, what happened there was that the defendants were trying to use things outside of, in that case, 208 to say, hey, listen, we can save it because of this constitutional provision that were not referenced in 208. The Court of Appeals did not take your guidance. Instead, it said, hey, the Voter Protection Act is going to protect it. This provision here is going to protect it. But that was not inside Proposition 211.
Well, if you remember, I mean, FAN, not my favorite case, since I dissented on that case. And I recall making the point of, would the voters have voted for that proposition without that expenditure? Maybe, maybe not. And now I find myself in the same position of, what are the principles that we should be looking at to make the decision whether the voters would or would not vote for?
And Your Honor, I'm glad you brought that up. And I appreciate in FAN that you rejected rejected the plaintiff's argument in that case that you could not just have the severability rule would go out dealing with the initiatives, and you reaffirmed what Randolph said. The problem is that there should be, as we put in our supplemental brief, there should be an enhanced burden, and there is a presumption of non-severability because of the importance of the initiatives. And getting back to Tunkey, which was the four-court opinion there, as well as Roberts, and harmonize the legislative intent that you're applying for statutory interpretation to initiatives. Because right now it's bifurcated. And in that case, and I appreciate what FAN said, that, hey, in Randolph, we were rejecting legislative intent. If you actually read that paragraph in Randolph, it says, to determine legislative intent, and then came up with the test. So the test in Randolph, quite honestly, is outdated. In that context, that's where I don't think, Your Honor, it is appropriate for this court to make that determination of pulling out the blue pen and determining what was viable and not viable.
So you've asked for an enhanced test and argued the basis of your argument as to the initiative is separation of powers. It seems to me that applies to us too. And the voters, among the things they did was to adopt a severability clause. And for us to apply a presumption against severability where that is an express legislative intention and action taken by the voters strikes me as counterintuitive.
But you have to look at what does severability mean then because of the clause and the heightened test. Is it still operable? We say no because you're not getting the super agency. In addition, is it inconsequential? If it's inconsequential, then you can sever it. And the reason being, Your Honor, based off of all the cases that we've presented before you, Malera, Hobbs, you keep on going through them all, it was all about principal provisions. What were the voters sold? The voters were never sold the severability clause. It was not inside the 100-word summary. It was not inside the legislative council. So you have a non-principal provision that's able to strike out a principal provision that was sold to the voters. That is what we're saying is a heightened presumption. And yes, I agree with you, Your Honor, based off of separation of powers, you should keep the blue pencil down and not strike out things, especially when it's principal. With that, if I could reserve the rest of my time. Thank you.
Okay, Mr. Frazier.
Good morning, Your Honors. May it please the court. My name is Eric Frazier. I represent the Citizens Clean Elections Commission. I plan to split my time with Mr. Samuels. I will cover both issues, standing and severability. Mr. Samuels will focus on standing. I'd like to jump right into severability where you left off, if that's okay with you. Let's be clear what's happening here, because I think with severability, it's easy to lose the forest for the trees. The voters adopted and enacted a campaign finance disclosure law to shine light on dark money. They wanted to know the source of the original contributions. They will know that source. They will get this information if this application of D is not not enforceable, which is all we have here. We have one narrow application of D that is enjoined. It's a preliminary injunction, not even a permanent injunction. So we have a preliminary injunction on one minor nit of D. That is not enough to take down the entire law.
Well, is it a minor nit, as you say? I wonder if subsection A lets the commission make the rules to actually implement asking for campaign expenditures, et cetera. That in and of itself doesn't prevent doesn't prevent the legislature from also legislating in that area. So now you could have the legislature saying, well, despite what the commission says, we want it done in a different way. Or even, and maybe they don't even conflict. It's just something else that needs to be done. As Mr. Johnson says, doesn't that then kind of change what the voters were sold, which was the commission would be the sole neutral authority, not subject to politics, that would be making the laws regarding campaign finance. And now you have, but for subsection D, preventing it, the legislature can, if you just have A, make laws. So I don't know that it's as minor as you say, is it?
Well, I think it is, Your Honor, and here's why. What the voters were told, especially in the 100-word summary that the plaintiffs are focused on, is that the commission would be nonpartisan. It still is. That the commission would be voter established. It still is. That the commission has rule writing and enforcement powers. It still does. None of those things have changed. There's nothing in the 100-word summary that told the voters they were creating a super agency. And I don't think they did. I don't think they intended to do that, which is why none of the defendants even cross-petitioned on the ruling. It's an injunction that merely says that the legislature can enact legislation. I don't think the voters thought that they were blocking the legislature from enacting legislation. But I think the voter intent piece here is a little bit misleading, because I think after Randolph and Fan, the focus of severability is on workability. Does this statute work without this other piece? Would it be absurd to for the voters to have adopted the statute without this other little piece? I think that's really an objective test, not a subjective inquiry into the voter intent. Randolph rejected a subjective inquiry into voter intent. Fan rejected a subjective inquiry into voter intent. The focus is on workability. And if there's any kind of purpose thing we're looking at here, it's would it have been absurd or irrational for a fully informed electorate, meaning a hypothetical electorate, not did these voters want to pass this thing?
Should we be addressing severability at this point anyway? I know we granted review on it, but it strikes me as odd that before the constitutionality of the different provisions is determined ultimately, that we would be even in a real position to decide severability.
I don't think you should, Your Honor. I think this case has come to you in a very strange posture, which, as you know, is why we told the court to deny review. You granted review now, so I suppose it's up to you what to do with it now. But I think the posture of this case is very troubling. This was brought as a facial challenge, and the plaintiffs have repeated over and over again that what they want is to enjoin the entire law, which, as you know, requires showing that all of Prop 211 has no constitutional applications. That's not what they've shown. They can't show that. The posture here is up on a preliminary injunction where we have a court of appeals determination that one application it would be unconstitutional, an application that has never been used or enforced in that manner. So I think the posture is pretty troubling, Your Honor. I point out that in the court of appeals, the judges in the court of appeals asked counsel for the plaintiffs, do you want something less than a total injunction, than a facial challenge repeatedly? And counsel for the plaintiffs disavowed that and said, no, we are bringing a facial challenge. What we want is to enjoin all of Prop 211. They're not entitled to that relief. Again, on severability, I think the key inquiry is workability. It's a test for independence. Can this piece of the statute work independently from the rest of the statute? Here it can. All of the campaign finance substantive provisions are still in the law. None of those things will change. Major donors will have to be reported. This information will have to be disclosed. The voters wanted information, they will get information. Very quickly on the request to essentially change the standard for severability, this court rejected that invitation in Fan, and I think the rationales that the plaintiffs have given you for changing the test both were rejected in Randolph and rejected in Fan, this voter intent proposition. As I explained to you, this is really about workability and an objective absurdity test. And what they're trying to do is essentially use the VPA to undermine the legislative power of the voters. The voters share the legislative powers, and they're saying that because the legislature can't fix it, the whole thing has to fall. But as you know, the voters included a severability provision. That's what the voters intended to do here.
Counsel, let me ask you a question about that, because with the Voter Protection Act, we're not there here. I'll confess that up front, but do we get to a point where through citizen initiative, the Voter Protection Act limits the ability for the legislature to otherwise engage in their plenary lawmaking role, where they're down to nothing but passing a budget? At what point, though, do we start looking at the degree to which the legislature's lawmaking authority has been restricted to find that there now is an imbalance between the legislature's lawmaking authority and the exercise of the initiative power under the Constitution for the people?
Well, I want to be very clear that the baseline rule under Arizona's Constitution is that the people share the legislative power with the legislature. That's the baseline rule. This power is shared. And then the people enacted the Voter Protection Act, which, as you know, is part of the Constitution and is just as much a part of the Constitution as the separation of powers provision. So those two things have to be read together. They are on equal footing because they're both part of the Constitution. I don't think this case presents the issue you're asking about, because nothing in A1 or A8 creates a super agency. These are normal, ordinary delegations of power, the sort of which the legislature adopts all the time. And what they're saying now is the legislature can challenge it, and they have standing to challenge it. And if it fails on this one little piece, the whole thing falls.
Well, if this was standard operating procedure, it strikes me that after our decision in Roberts, that's not the way we see separation of powers working going forward. And at issue in Roberts was a very generic and very broad delegation of power that was taken by the agency, and they ran with it. Here, this is about as broad and standardless a delegation of power as you could come up with. And I assume that was very intentional. We said in Roberts that the legislative power is inalienable. Neither the people nor once the people do it, it's protected by the Voter Protection Act in terms of how it can be changed. But delegating it in the first place is seriously problematic. And if the legislature has any part of this power, how is that not a core injury to the legislature that would at least confer standing?
I think the answer to your question, Your Honor, is this, and it's very important, which is that case came up through an as-applied challenge to something the agency actually did. And the remedy there was not to enjoin the entire statute or declare the entire authorizing statute as unconstitutional, because there's a broad scope of constitutional things that the agency can do. They can operate within a constitutional sphere. And if the agency steps outside that zone of constitutionality and usurps a legislative power, the court can remedy that through an as-applied challenge when the agency does that. That's not what we have here.
Although that was You're correctly depicting the factual scenario in Roberts, but Roberts talked about whether the legislature could even do that if it wanted to. Obviously, did not resolve it in that case. But how is that not an injury for purposes of standing?
Again, because nothing has happened here. So the core problem with the plaintiff's theory here, the legislature's theory, is that it has no limiting principle. The legislature can't articulate the harm because the harm they're articulating is stuff that the commission could do maybe someday, but it hasn't happened yet. That's not harm today. And again, there's no limiting principle because Justice Montgomery was asking, could the legislature sue an agency for something that a prior legislature enacted, for a delegation a prior legislature gave an agency, not for something the agency did, but merely because the statute is on the books. So can the legislature sue the Department of Transportation because the 36th legislature delegated authority? The answer is no.
How does this differ in that regard from our brush and nib case, where the ordinance was not applied, but it had such a chilling effect on the First Amendment rights? Here, separation of powers as well, the existence of delegating inalienable powers strikes me as being just as severe as in brush and nib.
So I want to make sure that I save enough time for Mr. Samuels. I will answer your question before I sit down, though, which is brush and nib arose under the actual controversy method for establishing standing. And in that case, the court recognized standing because brush and nib needed to know what it could and couldn't do because of the penalties it faced. If it guessed wrong, if it did something that the statute prohibited, they could end up in jail. That's what the court found. Here, there's not that kind of penalty for the legislature. If the legislature guesses wrong about what it's allowed to do within the separation of powers, there's no penalty. There might be a lawsuit, but the legislature will not be in jail, will not be subject to a fine. That's the kinds of cases that this court resolves under the actual controversy method when there's a serious consequence that the plaintiff will suffer.
So
I'd like to save time
I want
for
to ask
Mr.
another
Samuels.
standing question, but I'll let Mr. Samuels come up if that's what he's supposed to be talking about.
Okay, it is. Thank you.
And as he's coming up, so we don't.
You beat me to the punch.
So it's like Family Feud.
I'll try to introduce myself fast.
Go right ahead.
Good morning, Your Honors, and may it please the court. My name is Alexander Samuels. I'm here on behalf of the Attorney General. I had a great opening prepared, but it sounds like Justice Montgomery has something for me.
Well, no, because I want to key in on this to understand resolving the standing issue. Because quite frankly, when I look at the trial court's minute entry and I see what the Court of Appeals did, it's almost as if the standing was conflated with the merits analysis, and trying to unwind that has been problematic for me. To the point about standing, why does the legislature have to wait for the Clean Elections Commission to exercise the power that's been delegated to it to then find a particular injury, when what we're sort of dealing with here is almost the very structure of state government in this sense? We recognize that the people have retained the power of the initiative. Our government runs on consent of the governed. They have the ability to do that. If they want to revoke consent in a particular area, principally speaking, they can do that. But at what point does that balance tip such that the Republican form of government we're supposed to have is operating more as a direct democracy with the Clean Elections Commission, and maybe we have the Citizens Environmental Protection Commission that gets set up, exercising all of these legislative and executive authorities completely immune from the purview of the legislature?
There's a lot in that. I've got 6 minutes. It might take me 6 minutes to get through it.
Answer that, and then we can figure it out.
Yeah, I mean, your point about standing and the merits here, I mean, there's certainly questioning about that in the Court of Appeals, and I think that's been present throughout the case. I think one thing that's worth distinguishing there is the interpretation of the statute itself here, and the question of, is that statute constitutional? It seems to me the is the statute constitutional question is really what courts have meant by saying, don't look at the merits. I don't think it means you just adopt whatever the plaintiffs say the statute means just because they say it. I think that's a different thing. Now, as it relates to your point about these sort of broad points about separation of powers, and I heard you use the phrase direct democracy, and the question to Mr. Frazier about perhaps, I think you called it an imbalance between the legislature and the people that might be created by the VPA? Yeah, I think the honest answer is before the VPA, the Constitution very explicitly said the people in the legislature share power. Whatever the legislature can do, the people can do. I mean, really, you had a totally balanced set of scales. And yes, the VPA does create a bit of an imbalance. As a matter of fact, I would argue that's exactly the point of the VPA, and that when it comes to constitutional provisions, I think some of the points you've made would be perhaps good arguments to the electorate to change the VPA. But as the VPA,
Or maybe if the VPA gets misused, we have to relook about how it's addressing that balance, that relationship between the initiative power and the lawmaking power.
well, I might need more detail about what it would mean for the VPA to be misused, but I think my fundamental point is when it comes to constitutional provisions, this court doesn't pick and choose. The VPA is just as much a part of our Constitution as the separation of powers provision that's at the core of the plaintiff's complaint here. And so I don't think we can say that the separation of powers provision somehow trumps the VPA, even in some minor way. They must be reconciled together, and the VPA cannot be undermined by claims like the one here. And I think if this claim is allowed to proceed forward, it has really the potential to do that. And as Mr. Frazier alluded to and started to talk about a little bit, I'd really like to emphasize the lack of limiting principles here if the legislature has standing in this case. They have not articulated any limiting principle that would prevent them in future cases from challenging delegations of prior legislatures, from saying 10 years ago a prior legislature gave away this power. We now want to file a challenge that looks
Why
otherwise.
wouldn't they just change the law if they had a majority vote to authorize legislation?
I think our current era of divided government demonstrates exactly why, because they might not be able to. Certainly, it's the case that there might be situations in which they may not like a delegation. They might have a governor who's willing to sign a repeal, and certainly they might do that. But currently they might say, well, the problem here, we can point at the VPA and that prevents us from doing it. Well, they could also, in the situation we're talking about, point at the governor and say, the governor's going to veto it. That prevents us from doing it, and our only recourse is in the courts. I don't think that's good enough. I also think it has the potential to create imbalance in the wrong direction between the legislature and the people.
Can you, Mr. Sam, can you, one thing that Mr. Frazier brought up, and you've mentioned it too, of it's almost speculating about what will happen, what might happen, that kind of thing. Can you tell us, how do we distinguish between ripeness and standing? What degree does a ripeness of a controversy come into play in talking about whether someone has standing? Because it seems as if these concepts are being blurred, at least in this case, and in some of the arguments being made.
Yeah, I think courts have struggled with this for a very long time. I think the bottom line is they are overlapping. I think they are closely related, although obviously there's sort of different principles operating. But I do think ripeness is in a way a part of the standing inquiry, and that if you think about this through the lens of ripeness, you're really thinking, do they have an injury yet? And it still encompasses the question, do they have an injury? And I think Mr. Frazier's right that the existence of this statute itself is not an injury, and that's the claim here. Now, if the commission were to do something that the legislature thought exceeded its authority, or perhaps was within the text of Prop 211 but exceeded its constitutional authority, we may have a case that looks a lot more like Roberts in that situation. But that's not this case. This is a brand new type of case. I mean, if allowed to proceed, this is a facial non-delegation challenge brought by the legislative branch itself. That's entirely different than the way non-delegation challenges have typically come up through the courts, and I think it's extremely concerning. Now, I was mentioning earlier that you have the potential to create an imbalance the wrong direction here. In Fan, you observed in rejecting the sort of hardline severability rule there, that to allow the people's initiatives to be, or to not allow them to be severed, but to allow the legislature's laws to be severed would undermine the VPA because it would put the legislature and the people on different footing. Well, so too here. If the legislature is allowed to come into court and have standing to challenge delegations made by the people, I think in order to preserve the balance, you would have to say the people are allowed to come into court and they have standing to challenge the legislature's delegations. I don't imagine you're likely to say that, and I don't know what that would look like. Perhaps we now have voter standing in the way you have taxpayer standing in certain contexts. But that is a road that I'm guessing the court does not want to go down, and it should not want to go down that road. And so really the main point I want to urge here is that in addition to everything else that's been argued here about how there hasn't been an injury alleged, there really is danger here, even though we're in a preliminary posture, even though the posture here is a little bit strange. Even saying at this point that there is standing in analyzing this through the lens of the preliminary injunction factors, I think has the potential to do a lot of mischief. And I would encourage the court not to go down that road and instead to affirm.
Thank you, Mr. Samuels. Mr. Johnson.
Thank you, Your Honor. And real quick, the parade of horribles and the speculation that has just been presented is not before the court today. We were talking about Proposition 211, the plain language of 211. Of note, 974A is unprecedented. 974D in itself, unprecedented. You combine the two of them, it's a super agency. It's taking the power of the legislature in violation of the Constitution. It's that simple. If the voters wanted to do this, just as in 208, they needed to do a constitutional amendment, just like the VPA was. The VPA does not make this statute work. So by trying to bring in those other provisions, it goes too far. In regard to standing, real quick, Your Honor, I do want that nothing has happened yet. The existence of the law itself is what is offensive. It's offensive to the legislature. They should not have to wait till the commission acts to be able to come into the court.
But counsel, doesn't that argument go to their allegation of a lack of limiting principles here in your standing argument?
Well, no, Your Honor, there is a lack of limiting principles inside 974A in particular, and in its entirety, right? So you don't just look at 1 or 8, you actually have to look at the entire provision. But
Mr. Johnson, I understood the limited principle argument that they had by suggesting, and maybe the chief will be nice and let you answer the question, rather a limiting principle about addressing standing so that anytime an initiative gets passed, the legislature can't go into court and say, we have standing.
Your Honor.
Yes, please, go ahead and just answer the question.
Yes, Your Honor. The real issue, though, is the institutional injury. It's not any initiative. There's a whole bunch of other societal, economic issues that were on the ballot for the last 2 cycles. You all dealt with them. Those did not deal with legislative powers. This one does. And when it does, and it's particularized to the legislature not being able to effectuate its powers in passing of rules. Otherwise, we have advisory opinions and we have safe harbors that 211 didn't pass and the legislature did not offer. With that, Your Honor, thank you.
Great. Thanks, all counsel, for their arguments today and their briefing. It's very helpful. Very well done, as always. We will take the matter under advisement and issue an opinion in due course. So we will stand adjourned for the day. We're going to remain on the bench because now, as you probably all know, we do question and answer for at least another half an hour or so, if you'd like, with people in the audience. Counsel, you may stay or go. We will not be discussing either of the cases that were argued this morning. We'll give you a few minutes to get adjusted there. Also, we have, as I mentioned earlier, we have a new justice on our court, Justice Mary Elena Cruz, who was appointed sometime in February, January, recently. She has just started with us, but has not yet actually been on a case. She will be, first argument will be next week. But I asked her to come today to be part of our panel for question and answer. She is somewhere, where are you, Justice Cruz? With a real Justice Cruz, please stand.
She's going to make an entrance.
She's going to make an entrance.
Do you have her walk-on music?
I asked her to wear her robe so that we all blend in seamlessly, but I've also asked former Chief Justice Birch to stay because she has a great connection with this law school. You probably know her. She's taught here for many years. Her husband, deceased husband, taught here for many, many years. He was my professor, actually, and her daughter is a current professor here at the law school. You also might recognize her name on probably some nice room named after her and her husband. If somebody in the third row looks behind in their chair, you'll see my name on a chair that I put. That's all I could afford. But but I thought it'd be great if she could be here. And there we have Justice Cruz. There you are. Yep. So the way we proceed is that we see who's the first one that's brave enough to ask a question. As long as you ask anything except what we just heard in oral argument, and then we will be delighted to answer any of your questions. So we have 2 microphones here on either end by Alberto and by Katie, just for that purpose. So who wants to be brave? If not, we'll just start talking because that's what we do.
Hello, so thank you for being here. My question is, I think some of the topics that are discussed before you are very personal or could resonate in, like, I think maybe that's a very personal way. So when does your vision of what you want in our state take, like, tip the balance? I just want to know, like, how
Take
do
the
you
what?
handle that?
Oh, I'm sorry, I missed the last part. Take the what?
Like,
Tip the balance.
Oh, tip the balance.
So
Oh,
when it
okay.
actually is significant that you might lean in one direction or another, if there is ambiguity, or if the case really is 50-50.
Okay,
When does your vision of what you want?
Okay. I think if I hear the question correctly, and not regard to either of the cases that we just heard of what we might think, but I hear the question being, when we get these arguments and stuff, and when things are just, pretty close or tied, I mean, what type of considerations might we have? So that's a really good question and really difficult. So I'm going to ask the Vice Chief Justice to answer it because that's what I get to do. And so this is Vice Chief Justice John Lopez, who also is a graduate from this law school, correct? Indeed. Yes, and you've been on I always think I should memorize, yeah. Here, you can clap. Just, please don't boo when I introduce U of A law graduates.
All right, my answer may be somewhat counterintuitive, and I'll start by saying that I think that the opinions that I've authored or the majority decisions that I've enjoyed the most are the ones in which the conclusion is probably something that I would have voted the opposite way if it were on a ballot and I were exercising my rights as a citizen. Because I think when that happens, and we don't tailor our decisions to get an effect from the public, but when people have assumptions, kind of like the assumption that's built into your very reasonable question, they assume that judges in a close case will put their thumbs on the scale to achieve an outcome that comports with their predilections about policy, for example. And I know no one on this court does that. And that's why, in fact, I enjoy decisions where if it were on a ballot, I would have voted the other way. One of my favorite quotes on this topic is from the late Justice Scalia, and I like it so much that I have it in my office a couple of places. And it was a quote from a speech he gave. It wasn't an opinion. And he said, if you're going to be a true and faithful, fair and faithful judge, you're probably not going to like your conclusions all the time. If you like them all the time, you're probably doing something wrong. And I think we all take that to heart. We follow the law. Many of these cases, by definition, are close cases. But the ultimate decision is determined by which argument is that much more persuasive. And what we all recognize is that our decisions, their merit is determined by the people who view them. And whether they like the decision or not, the most defensible, intellectually defensible, consistent with the law, consistent with our jurisprudence, the conclusion that is most consistent with that is most persuasive, I think, speaks for itself. And that's always the objective, to try to get it right under the law, irrespective of the outcome and whether we like it or whether we don't.
Other questions? Okay, I see you down here. In case you're wondering, Justice Lopez, he's not that much of a nerd. He also has, it's 5 o'clock somewhere in his office. So. Yes.
Hi, my name is Tessa, and I was curious to know about the questions that you guys ask when you're given these arguments. Are they things that you come in prepared to ask? Do they come up? Are they ever targeted to try and elicit a specific response? like trying to get them to maybe convince some of the other justices that you know or are unsure of how they're thinking? What kind of thoughts go into your questions?
That's a great question, and I'm going to ask Justice Clint Bullock to answer that. Clint went, to UC Davis for law school and has been on the court since 2016, right?
Yes.
And Justice Lopez on 2019. Right?
And I'm making up for not going to
17.
ASU Law School
Yeah.
by teaching here every fall. So, also, you guys all look great. So nice work. Normally we don't have such a well-dressed audience. So, Tessa, really great question. And the answer is all of the above. Everything you said goes at least into my questions. I do, when I'm preparing for the case, when I'm reading my clerk's memos, when I'm reading the cases, if a question occurs to me, I write it down. Then I go over them before the argument and decide which ones are still salient that I haven't resolved in my own mind from having read the briefs and that sort of thing. Do we sometimes ask questions to persuade our colleagues? Absolutely. Do we sometimes ask softball questions when the side that we are inclined toward ruling for maybe struggling a little bit or not getting to the gusto? Yes. And that is one of the most difficult skills to recognize as a lawyer is when you're being thrown given a softball, what you're supposed to do with that is hit it. Just a quick aside, and the chief knows this, a former colleague of mine who is a spectacular lawyer, first time she got a softball question, she said, "That's a red herring, Your Honor." And I filled her office with paper mache red herrings. And she now uses red herring in every single argument as her talisman. But yeah, really, all of those things go into it. But sometimes the questions come up during oral argument when an advocate will say something that, like, gee, that doesn't strike me as right, or an argument, one of the things you do in oral arguments, or you try to do in oral arguments, is to present the case in a fresh way, a different way, a way that's more easy to absorb, and sometimes that gives rise to additional questions. So all of the above.
Okay, other questions right there? I lost Katie. Oh, there she is.
I think you need to move faster, Alberto.
Yeah.
It's a race. Who's going to get it?
Yeah, who's going to get there first? Okay, go ahead.
Yeah.
Good morning, my name is Lexi. I was just curious, after you hear these arguments and processes, is it more of a collaborative approach where all of you can discuss, or is it very individualized? Yeah, I'm really very open-ended question. What does it look like after this?
Sure. Good question. And I'll turn to Justice James Bean, who went to U of A for law school.
We're all U of A on this end. Yeah.
Well, I do have a tie to ASU. My daughter, who's a deputy county attorney, went to law school here at ASU. So I didn't want to be the only one that not get applause from you all, so I throw that out there. Lexi, excellent question. And yes, after oral argument, usually we have it down at our courthouse, obviously. We adjourn from the bench and go into our conference room. And that's where we, the seven of us, sit down and discuss the case. And we go in order of seniority, except the chief goes last. So we go with the vice chief and then in descending seniority, and that's where we just lay all our cards on the table, so to speak. We discuss the case and where we're leaning. What I really enjoy about this court is is no one comes in hard and fast like, this is it. Usually it's prefaced with like, this is where I'm leaning right now. I'm open to being persuaded when the rest of the six speak. But then we kind of lay out our positions on the case, and we literally vote at the end of our discussion, and the chief will keep tally and will assign the opinion based on kind of a who's up to write the next opinion. We have a very robust discussion after oral argument, and then go around the room and, like I said, vote. Now, like Justice Cruz and the Chief Justice, I served on the Arizona Court of Appeals for 2.5 years prior to me serving on this court. And what we did there is that we would pre-conference the case before oral argument. So we kind of knew going into oral argument where the 3-judge panel was going. We don't do that on the Supreme Court. We work up the cases in chambers. We have these great law clerks that are sitting here today, and they write chambers memos, and we discuss the case in chambers. And I really don't know, in large part, where my colleagues are at until after oral argument. And then we discuss the case in conference. But on the flip side, the Court of Appeals, we had a draft going around before oral argument, and then we'd conference the case and then do oral argument. So it's a little flipped. I enjoy kind of not knowing, it's a bit of a high wire act going into after oral argument to see where you're at as opposed to your colleagues. But it's a very robust collegial atmosphere, which I really appreciate as well. There's some state Supreme Courts around the country that don't have the collegiality that we have. And I get along with all of my colleagues. We're all very friendly, but we do have discussions that sometimes we disagree. But it's never nasty or inappropriate. Everybody states their case, and we respect everybody's opinion, and we go around and discuss the case. And like to the Vice Chief Justice's point, we just all want to get it right as to the law. But thank you for the question.
Justices, thank you so much for being here. My name is Brandon.
Oh, there you are.
My question is, for better or worse, there's a lot of discussion on how AI is transforming the practice of law. I wanted to know, do you see AI as transforming the judiciary as well, and if so, in what ways?
Okay, I think that's a question for Justice Bill Montgomery. Justice Montgomery, you went to ASU as well, right? Law school
did.
at ASU, and teaches here as an adjunct as well.
Yeah, and each semester I co-teach a seminar on victims in criminal procedure with Professor Steve Twist. So if you haven't taken the class yet, you need to. Do I have any students from my current class here? They will hear about it later. So it's a great question. And, courts around the country are always trying to figure out how to leverage current technology to ensure that we're doing our jobs as well as we can. AI presents several challenges and opportunities. In some ways, we've been using AI for a while. Anybody here use Westlaw? Yeah, that's sort of an AI function in searching cases to give you relevant jurisprudence. And in terms of using AI for writing briefs, I'm sure you've heard there have been some cases where AI will return case citations that don't really exist. And we have a committee in place right now that Chief Justice put together that's looking at utilizing AI within the court system. To the extent, and this is my personal view, this question's come up a couple of times in the last several years. Can AI actually replace the judicial function itself? And I'm a hard no. One of the things that makes the law so interesting and that I enjoy most about it is the human interaction. And there are always going to be interstices in statutes and in applying the law to cases and dealing with facts that are going to be novel and unique. And AI only knows what you put into it. I don't believe AI can really innovate or think to the degree that a human mind can. And that's what distinguishes us from other animals, and I think will always distinguish us from AI. And so to that extent, then, where I think there will always be a place for a human being in a judicial role to be able to see how the law should fairly be applied to a specific set of circumstances with the law that we have. So is AI interesting? Yes. Can AI be applied within the judicial area? Yes. But do I think it can ultimately replace judicial officers? No.
And you probably are wondering too, can it replace lawyers? I think the answer is no. So you're lucky. Good thing, right? Since you're here. All right, next question. I saw somebody down here before. Yeah, you run downstairs, not up, though.
Thank you. Krishna Smedya. Could you talk about the role of, how you think about the role of the state Supreme Court relative or vis-a-vis your colleagues on the courts of appeals and the superior courts? What kind of deference do you give to the work and the decisions of your colleagues?
Great. I'll ask Justice King, Kate King, to answer that. Justice King is also a U of A graduate.
Just a minor applause. Well, we have some of the legal issues that come before us. It depends on the case before us. So depending on the precise legal issue that's before us, and in particular, you probably noticed, but when we accept cases for review, there's a petition for review that's been filed, and we oftentimes, the petitioners will lay out, okay, here's the question, or here are the two questions. We accept those questions if we decide collaboratively to accept the case for review. Sometimes we accept those questions as presented. Sometimes we find, though, and this is just sort of a side note, that sometimes the questions presented, this is kind of a practice point, the questions presented by a petitioner can be argumentative or maybe kind of go astray from really the core legal issue that really needs to be determined. So at times we do rephrase the questions presented. But depending on the question that is presented in that particular case, sometimes the standard will be abuse of discretion. And so we have to look at, the trial court had the opportunity to make like credibility determinations with witnesses. And so there will be an abuse of discretion standard that we apply when we're determining the legal issue that's before us. In other cases, it's a de novo review. And so we are kind of looking at it, the legal issue again, like on a motion to dismiss, for example. We are looking at it as a matter of law with the record, and we're looking at under a de novo review standard. So depending on sort of the standard that's before us, that implicates the cases. But I do have great respect. You talked a little bit about sort of the deference that we give to our colleagues. We have a really fantastic judiciary here in Arizona, and a lot of that stems from our merit selection system with the appellate courts in Arizona. So, for example, the Court of Appeals, if you're like Justice Cruz and you served in Yuma County, she was a direct election for a Superior Court judge. She served as a Superior Court judge in Yuma County for a while, but our Court of Appeals and Supreme Court, we go through, and then the four most populated counties in Arizona go through a merit selection system where you have to go through a nominating commission that will then vote, screen applications and send a list of names to the governor. And the governor appoints from that list. And that's what Justice Cruz just went through, was appointed by Governor Hobbs just about a month and a half ago or so. But it's a very, very rigorous process. And I point out, I do have great respect for our judicial colleagues throughout the state of Arizona. And so, for example, I'll give you an example. At least when I'm writing an opinion, rather than saying the trial court judge abused their discretion, I prefer to say the trial court judge erred in making that decision. I just think those words kind of matter, and I think about those things when I'm writing opinions, and because of that great respect for our judicial colleagues, and we really do have an excellent judiciary here. So, a few side points that I wanted to point out, but I'm very, very proud of our Arizona judiciary.
I hear one at the top somewhere. Run, Katie. No, I didn't really mean you had to.
Hi, my name is Britney. My question was just prior to becoming a justice, was there a specific event or experience that you had that you feel has still continued to impact you in fulfilling your duties now? And maybe just what is that? And just talk a little bit more about that.
Great, sure. And I will turn that to our newest justice, Justice Maria Elena Cruz, and who we do not mean to put at the child's table as any kind of any indication of the great respect that we have for Justice Cruz, who, as Justice King mentioned, was a Superior Court judge in Yuma County and on the Court of Appeals for several years as well. So she has more than just a month and a half worth of reflection before becoming a judge. So go ahead, Justice Cruz.
And attended U of A. But I have accepted every invitation to speak at this law school, so there is that. We're part of the greater community. And yes, they are hazing me by making me sit at the little kids' table. They seem like a fine bunch, don't they? The things you learn when you come across and see behind the curtain. Actually, I'd like to start by saying that, yes, it's been a little less than a month and a half that I have been a member of this court, and what a joy it is. What an incredible group of people. We should be really proud of our Supreme Court. It is exactly what you see here. The welcome that I have received could not have been any better than it has been. So with that, I'll try to answer your question. Personal experience that I had that I still carry with me today. So as you may or may not know, I grew up in Yuma County. I moved to Yuma from Puerto Rico when I was 14, and that was an excellent experience growing up in rural Arizona. But later, I was involved in a serious car accident, and I was on the path to becoming a teacher, an elementary school teacher. That's what I thought I wanted to do. And I wanted to do that because it was important to me to do work that had an impact in people's lives. And as I characterized it in my early 20s, work that was important. And so as I'm on that path, I'm involved in this very serious car accident, of course, because I'm in Yuma. It was car against tractor machine, and opened my car up like a can of tuna. Now, here, if you're involved in a car accident, you can't take two steps without running into a personal injury attorney, right? They are everywhere, everywhere. That's not the case in communities like mine. It was actually through connections that my dad had that I was able to get an appointment with a personal injury attorney. And I realized during that interaction that he was uniquely positioned to help me vindicate my rights. And that meant something to me. Also, I was learning at the same time that a career as a teacher was going to put me probably below the poverty line for a long time unless I was married to someone else who was the main income earner, and that could not be my plan. So I started to look at what this person was doing as a very unique opportunity and something that I could do. And so I asked him as he's talking about the cars, and also I was thinking, he's going to make a lot of money for shuffling some paper around. I don't remember him sitting next to me in that car as I had that accident, but he's going to take a third of my check. At any rate, I asked him what it is that you have to do to be a lawyer, and his first answer was, the law is a difficult profession for a woman. Well, that didn't dissuade me. I thought, he doesn't understand my question. I'm not asking him whether he thinks that I can do it. I know what I'm capable of doing. I'll do anything that I really set my mind to do. But I asked him again, and he finally said, well, these are the steps. And I thought, I can see myself serving my community, helping people in this very meaningful way. And of course, I went to law school, and then you get exposed to lots of other things. I was exposed to criminal law, and then I thought I would be a career prosecutor. I found great joy in advocating for the rights of people. And I ended up taking a turn, but stayed obviously with my mission of being of service. And so that is something that has carried through with me. And now that I am in this unique position of being a member of our Supreme Court, it's an absolute privilege to be able to help advance the current strategic agenda, which seeks to address that very issue of bringing access to justice, legal representation to people all around Arizona, so that people in what we call legal deserts can have access to representation and not have it be a case where you have to have contacts to be able to have representation.
Okay, maybe one more question, then we can ask Justice Birch. Do we have any more up there?
I can just.
Oh, there's one up there.
Or you can make something up.
Thank you. I'll speak from way up here on the sidelines. So we are all in law school to learn how to think like a lawyer. But creating convincing and persuasive legal arguments isn't the only skill set that we need to have to be successful in a career. So what is a secondary skill set that you would recommend to us as law students? That we can go into negotiation, public speaking, which I'm terrible at, sorry. Getting into organization, following procedural rules. What is a secondary skill set we can take away from our time in law school?
Great. And if you hadn't asked a question, that was along the lines of what I was going to ask too. So we could take advantage of former Chief Justice Birch's experience, the great experience that she's had both as an attorney and on the court. She was also on the Court of Appeals, Supreme Court, and Chief Justice here from she was the first Chief Justice when I arrived at the court. So it was what, 2010 to 2014, right? 9 to 14. Also ASU grad, and I already told you all the other things. She's an ASU person. So Rebecca.
Yeah, I'm just a person from the Phoenix area, so I have 3 degrees from ASU. A lot of that had to do with the fact that I didn't have a lot of money as a student, so ASU was the choice. It's a great question. There's a lot that goes into being a lawyer, and we've already talked about analysis of the law, and that's what you're going to do in your classes, and it's what you're going to do in practice. But there are 2 other skills that I really hope that you will consider developing. Distressingly, you've asked a former director of the legal writing program, what's a skill you might want to develop? Obviously writing. You will write a lot. You will write more often than you will be in court. Early in your careers, you'll be writing to partners, you'll be writing letters to clients, you'll be putting memos in the file, learning to write quickly, clearly, getting over any writer's blocks that you have. These are all important skills, so continue to work on that. But the other one that I think is very important and sort of underrepresented when people ask what skills they should develop, in addition to being a kind human being and empathetic, are skills, I suppose they could fall under the larger cloak of acting or public speaking, but you're going to have to do a lot of this, even if it's to address your clients in your office. You're going to have to convince them that you have the knowledge, the skill, the empathy to handle their cases effectively. We had terrific arguments today, and I encourage you from time to time, go down to the Court of Appeals, go down to the Superior Court. You'll see both good arguments and you'll see not such good arguments. One of the best experiences I had as a first-year student, right before moot court, I went down to the Court of Appeals to listen to an oral argument, and the one I listened to, was distressingly bad. And it was the best thing that could have happened to me because I thought, I can do that. I can be at least that good. So I would encourage you to work on your writing. Make sure that you know how to do some public speaking. It will be important in your careers.
Great, and to add that plug to that, you can also look on the live stream, because all of the Supreme Court and the Court of Appeals, you can look live stream, and actually we save it too. So if you're interested in a case and you just want to get a snippet and get an idea, you can just go through them, and it is a great educational tool that you have there, just watching what happens. So last but not least, I just want to, because I want to wrap up so you all can go to class and we can go conference and that kind of thing. I didn't introduce myself. I'm Ann Timmer. I'm the Chief Justice. I went to ASU's law school as well. So, come to think of it, as did my husband, who I met in law school, and we currently have a daughter who's a third year here. So we are ASU everywhere on that. But, I want to thank all of you for attending. I have a company tell me I have to say all this. So thank all of you for attending and such. It is a great opportunity. This is what you're going to be. You're going to be lawyers, and you need to see how things work. And it's valuable to see that. I hope you came away with both arguments that, gosh, even if you have a gut impression on something, there are two sides to the story. Sometimes there are multiple sides. And I think lawyers, you might be the last profession, we might be the last profession where people really sit back and think and try not to rush to judgment and consider things. And I thought today was a great opportunity to see that. And I hope you all bear that in mind when you represent your clients someday, just stepping back and think, and not so much engaged in I have to win at all costs, but think and what's just and right in a particular situation for your client, or perhaps even for others beyond your client. I want to introduce to you some people. First of all, we all have law clerks. We're lucky to have two law clerks who come and work with us, usually right after they graduate, but not always. Sometimes they'll come back after practicing for a little bit to get that experience. So if you could all just stand up just to embarrass all of you, right? Yeah. They are where you were either last year or the year before, wherever you are in law school, with the exception that at least I think that most of them so far have taken the bar. I know everybody who's taken the bar has passed the bar, which is good. And they're a delight to work with. It actually is one of the best things about being an appellate court judge, is the opportunity to work with law clerks and to see them come back. And I won't say who, but in the cases we had today, there were former law clerks here and there, scattered here and there. And it's always nice to see people that have had that experience keep going up the chain. I also want to thank, of course, all of everybody who's organized this for us, which is Alberto and Katie. And I have to call them out because I kept saying run faster, run slower. And that's really not very nice. They do a lot for us. And also thanking security, that we could never go anywhere without making sure in this day and age that we're secure. So thank you for security, for keeping us safe and everyone here safe. Also thanks you to Arizona State University College of Law, especially Dean Stacy Leeds and all of the leadership who helped plan and host the event. We know we're a disruption to your classes, and we really appreciate coming out, you all coming out, and you all looking so nice and professional, which you probably were like, I just wanted to wear my yoga pants today. Why am I doing this? I get it. Justice Lopez is wearing yoga pants right now, but no, yeah. But it's nice when you can't cover it up with a robe to have that professional look. Today his day. Alrighty, and I think I've got everything. Yeah. Oh, thank you to the AV department and our clerk's office, and also for everything they've done today. I think I have covered, and so we will stand adjourned. Yeah, go ahead. Perfect.